Welcome to Ballantine Law, clear, practical legal advice that works.
My name's Alyssa Holloway. I'm a senior solicitor at Ballantine Law, here with Sidney Jennings, a senior associate at Ballantine Law, and today we're discussing retail leasing.
I think one of the good things about retail leases, which we can get to, is that they do require, in most instances, for the tenant to get legal advice before they sign, which is something that gives us an opportunity to review a lease and perhaps the heads of agreement or the terms they've already agreed to before they become legally bound to.
Yes, I agree.
So can you explain to us maybe, and for the viewers, what the difference is between a retail lease and a commercial lease?
Sure. So a retail lease doesn't necessarily have to be a retail shop. It can be a shop that's in a shopping centre.
So a retail lease is a commercial lease, but it's a lease for a retail shop or a premises that is in a retail shopping centre.
Yeah. So a doctor's office that's located in a retail shopping centre could still be a retail shop lease.
While a doctor's office standalone would just be a commercial
lease.
Yeah. What's the main difference between a retail lease and a commercial lease practically that our viewers would want to know about?
So the key difference between a retail lease and a commercial lease is that a retail lease is governed by the Retail Shop Lease Act, which provides some further protections and provides further disclosure obligations on the landlord, which generally just means that there's more upfront information on costs, information on the centre as a whole, car parking, that sort of thing.
And importantly for our clients, the landlord's fees cannot be passed on to the tenant in a retail shop lease.
Yes.
Could you tell us perhaps some clauses that tenants often overlook when they're considering retail leases?
I think sometimes we're so focused on the now and entering into the lease, sometimes they forget to consider what happens at the end of the lease and make good clauses that are rather far-reaching.
And I think too, people will often get perhaps a fit-out incentive when they're starting a retail lease. So funds that the landlord are prepared to front for works that you're doing to that premises. Maybe you're changing it from a cafe that only did coffee to a restaurant that's serving food. That can be quite expensive. But at the end, the landlord expects you to return it to blank shell, which can be very expensive. And so it's important to consider these things before you sign.
Or even if the landlord doesn't expect that, you should consider if your expectation was that you would get to take that fit out with you, it may be that that's now the landlord's property, and often that is the case.
What are some hidden costs in leases, would you say?
There's a clause in the lease usually that lists out the costs that are payable by the tenant, and it's easy to just skim your eyes over that and say, oh, yep, that seems reasonable. But I think survey plan fees in particular, if you're leasing part of a lot and the landlord doesn't already have a survey plan setting out the parameters of that part and they pass on those survey costs to you, they can be significant and talk upwards of a few $1,000s depending on the complexity.
Yeah, and often I think in retail leases you might be sharing a portion of the outgoings, including maybe usage for air conditioning or even water for the whole part in the retail shopping centre. And if again you've got a business that sells clothes, perhaps you are not going to be using the same amount of those resources as some of your other tenants, and it's important to understand that you may have no recourse in this respect.
Yeah, the laundromat that's across the aisle from you might be using 90% of the electricity for the centre, but you still may be liable for a set portion based on the area that you lease. So that's something to consider, whether your premises are separately metered.
Can you negotiate the terms of your retail shop lease?
Absolutely. Usually when we receive a lease, there may have already been key commercial terms that have been agreed to. Depending on what's already been signed, there's usually still an opportunity to negotiate those. We would encourage clients not to sign any sort of binding heads of agreement or offer to lease or anything like that until they've had a chance to get legal advice, but also financial advice on the terms of the lease, which is another requirement where there's a retail lease, that the tenant financial advice from their accountant. Even if you've already got some agreed commercial terms, there may be room to move on some of the sort of finer details of the lease, like the make good requirements or the level of insurance coverage, or even just some of the broader maintenance obligations if there's things that you think the landlord should be picking up the bill for.
So we've signed a lease now, our client's been trading for some time, and unfortunately things have taken a bit of a turn. What happens when the business can no longer pay or expects to not be in a position to pay their rent?
Unfortunately, it's a tricky situation, especially when you consider the security that's on the line. But generally speaking, there's not going to be a right for you to wiggle out of the lease because of interruption to your cash flow of your business. You may be able to sort of seek to negotiate an exit out of the lease from the landlord, which may involve them drawing upon whatever security you've provided them in the meantime, whether they choose to retain your bank guarantee, your cash bond, whatever you've offered.
We often encourage clients too, I'd say, consider the demand for the shop that they're in. If they anticipate that when they vacate, that land may stay vacant for some time, their landlord may be motivated to try and keep them in, and they may be motivated to reach some sort of agreement with them as to a rent abatement, whether it's temporary or they're prepared to offer that as a credit so that a client can get through perhaps a difficult time. I think getting ahead of your financial circumstances early, speaking to an accountant, speaking to a lawyer, and then potentially speaking to your landlord is a good first port of call.
And I think that they're more minded to negotiate before you've stopped paying rent, because if you're already in default and they're already considering steps to be taken, they're probably not in the best frame of mind to be entering into negotiations. If you can get ahead of it, and I know that's not always possible, but if you can get ahead of it by coming to speak to us, getting some advice and putting a proposal to the landlord, that's always the best foot forward.
And I think you'd agree that a lot of our clients entering into these retail shop leases, they're doing so through a company entity, perhaps as a corporate trustee, but many of them are being asked to provide personal guarantees as a term of the lease. Can you give us a brief explanation on what a personal guarantee is?
So essentially your company that you've set up to lease the premises and run the business from those premises, that's likely the key asset of that business. So they then look to, well, if we needed to enforce your obligations under the lease, how do we go about doing that when this company owns no assets other than the business? So they look to have a director, or if there's multiple directors, all of the directors, or some, or whatever their requirements are, to sign a personal guarantee, which essentially means that they can come after you personally and your personal assets in performance of the tenant company's obligations under the lease. So if you own a house in your personal name, but you've signed a personal guarantee for a lease, you then are unable to pay rent and the landlord decides to take enforcement action, they can pursue you for your personal assets, and that includes your personal property that you own.
For more legal insights, subscribe or visit ballantinelaw.com. We're here to help.